Hello, everyone. Welcome to our webinar. I think it's the best time to start. Let's not wait anymore. If someone wants to join, he will do that. So, and we will be like functional a bit, and we will start. Let me start with like short introduction, not too long, but still say a couple of words about us. My name is Anastasia Kozukhova. I am a junior partner at the law firm Icon.Partners. And just to provide you with the main numbers about our company without long introductions, like 12 years on the market, 40 plus countries. So we are providing our clients with full legal support all over the world. And at the same time, our main focus still are corporate, tax, financial law, as well as intellectual property issues, which is the topic of today's webinar. And joining us today are experts, Alina Boots and Anastasia Monarchuk. So both lawyers who specialize in intellectual property law with solid backgrounds. So we'll explain us today how to protect your ideas, names, and creative work. So hello, our lawyers.
Hi, Anastasia. Thank you for inviting us today. So yes, my name is Alina Boots, and I'm a legal professional with over 10 years of experience in the field of intellectual property. So here in the company, we are specializing in protecting and registering trademarks, copyrights, industrial designs in such jurisdictions as the United States, European Union, the UK, Canada, and Ukraine. And we are also assisting clients in expanding their IP rights internationally via WIPO procedure under the Madrid Protocol. So our goal is to help businesses and creators secure and manage their intellectual assets effectively in the global markets.
So greetings to everyone. I'm also happy to join today's webinar. As Alina mentioned, we really focus on different areas of law and different specific questions. Just to add that also our clients often refer regarding the release of different applications, which use, of course, the IP. So we also check what is necessary for such release, and also help with the IP questions for e-commerce and tech businesses. So really a lot of different questions, and I'm already waiting to share all the insights with you.
Great. Thank you so much for your introduction. So, by the way, I'm also the lawyer, but today I'm going just to moderate this webinar. I'll be moderating, I'll be asking maybe some tricky questions. So to get as much useful information for our participants as possible, and make it not just like theoretical quoting, yeah, but really something, some practical knowledge that everyone may use directly after the webinar, running her business, right? So just a couple of technical moments, let's say. In case you have, it will not be like I said, yeah, it will not be like quoting some legislative provisions. It will be like lively discussion. So I will ask questions, our experts will answer them, and it will be like questions, maybe some discussions. I don't know if we have the same point. In case no, we will discuss, and I hope get the same point, yeah. Then If you have, it's for participants. If you have some questions, please leave it into the chat so you can write them. And in case we have time, so after the webinar, we also will check them and answer. As a moderator, I will try to summarize from time to time all the things. Just so you can take something or your laptop, what is more convenient for you, maybe some special thing, yeah, for making notes, because I will summarize and you may take some information. So in case, just for usage in future. Also, as for timeline, it will be, as it was said, like an hour and a half, maybe a bit longer, since I know that we have really lots of things to discuss today, and so just cannot wait to share all these things with you. So I hope that I said, so covered everything maybe about our agenda. So no more wasting time. Let's get started. So we'll start from the theoretical part. Don't think that it will be like what, but still we just before we deepen into some special things, yeah, we need to provide you with foundation of some terminology of basic things so you may understand. But it will be put like simply, so you understand what we're talking about, like the main terminology, the classification, yes, and it will make easier for us to go further and to deepen our knowledge. So, and the first my question, like the easiest one, but still we need to understand. So, could you tell us what is the intellectual property? Just the main thing, and please put it simple, okay?
Yeah, okay, just in simple words, intellectual property or just IP, these are the results of the human creativity. That is something, some intangible assets which are interesting, unique, and bring something new to our world. So these are different designs, logos, texts, music, photos, and so on and so forth. And what is essential here is that when you or exactly your business have some specific object and you have all the rights for it and this object is rightfully protected, so then you can really receive the profit from it. You can protect it from the unauthorized use and just to use it in any legal way to make some goods, yet to make some benefit from it, and that is essential in IP.
Okay, so, but what if we speak about different types of intellectual property, right? Since talking about some creative results, outcome of the work, it may go to different things, right? So let's make it like short classification. What kinds of intellectual property we have, so what we can protect legally.
Yeah, actually, the types or categories of IP, they are different and then can vary country by country. But if we sum up just in general, for general characteristics, we can name such main groups. First, patent law. This is the area which protects inventions, utility models, and we will further discuss that it's also about some processes or methods. The second category is copyright and related rights. It is about the text, music, designs, and anything, something creative. The next category is, I would say, more related to business because it's about trademark and trade secrets. They protect some logos, designs, yeah, and some specific, I don't know, information, yeah, or processes in business which can be unique and also bring the benefit. And I would say that as we see in our world, every day we see the new objects which arise, the 3D prints, holograms, and so on and so forth. And the legislation is also developing in this case. For example, in the European Union, we see the reforms which are aimed on the protection of such interesting and new objects, in particular as the designs. Yeah, also what is essential here is that we have been here the question on how to protect the software and the program codes. And what is interesting that mostly they are protected under the copyright. Of course, we will discuss some exceptions when they can be protected under the patent, but still, like in most cases, it is about the copyright.
So, okay, I got you. So then we may summarize here. So different classification depends on the legislative approach of the country, but still, like the main categories, it will be patents, right? So like inventions, utility models, as you can see actually on the slide. So copyright law, and usually it's something like, for instance, I don't know, novel or software as well is covered by copyright law, different things, photos as well, and so on and so forth, and related rights. Then like another group, it's trademarks as well, trade secrets maybe. So and some other categories depending on the legislation. But still, okay, we understand these main categories, remember now them, but let's provide maybe the main features of each one, because from time to time clients come to us and we see that they do not understand, and it's normal thing, yes, they're not lawyers, so they have their own objectives, but still do not understand the differences, for instance, between patents and trademarks. So in which case we need to protect and register our rights for the first thing or for the second thing, yeah. And here we need to really understand what we are going to protect. So will not go further, because I know that our expert will understand, will describe now all these things to us. But still, let's go one by one maybe, yeah. And my proposal is let's start from the trademarks, for instance, since they are so popular, and we really provided you with some interesting examples as well. Actually, I forgot to mention that. So we received lots of questions in your forms, and we tried to group all of them, yeah, and integrate into our webinar. In case there were like some common questions, so and more specific ones. So in case we will have time, we'll cover also this second group, like more specific, yeah, or in case not, so you may leave them also into the chat here, or just contact us after the webinar and we will discuss so additional. Okay, let's get started. Yeah, let's get straight to the point and start from the trademarks. Tell us, what is it? What is its main features? Oh, okay, I see the slide when we can compare. Yeah, trademark it. Okay, Alina, your turn.
Yes, thank you. Yeah, here at this slide, we can see the main features of the trademarks and patents and how to compare them. And I would like to start especially from the trademarks, as we are getting the biggest amount of the request from the client, especially regarding trademarks, their registration, protection, and agreements relating to the trademarks. So it's the biggest question and the most interesting question for our clients, as we can say from the practice. So the main feature of the trademark is that it protects your brand. Things like your company name, your logo, slogan, or any other feature that helps customer recognize your product or service among others in the market. So trademark is a way to legally secure the unique identity of your business. And beyond basic protection, registering a trademark has several strategic advantages that are good to know.
Mm-hmm. Totally agree, by the way. So let's do not perceive the trademarks like something that we just need to do or cannot to do. Yeah, it's not all only legal protection, but it still may provide you or your business with some additional benefits. For example, we know that in some countries, you know, these things like the highest level of domain, yeah, which is like the ending of URL or website, for instance, and usually it's the same as Alpha 2 name of the country, for instance, UK for United Kingdom, US for United States, UA for Ukraine, and so and etc. So, and in some countries, it's also in case you want to receive such kind of domain zone, yeah, you cannot do it without a registration of trademark. So only in case you register your trademark and it's approved by authorities, so you may have access to such respective, so such reputable, let's say, yeah, kind of domain. Or another big thing is about so your image in front of different investors. So why usually clients also come to us and ask for request trademark registration. So they want us to make their business more attractive to investors, because a registered trademarks, it still shows if your approach to business is serious, yes. So if you contributed some time, money, or efforts, of course, I mean money like costs for legal support and all these things into your business. Because if you are not serious, maybe you will not do, yes, all these things. That's why investors see that your brand is legally protected, and that you've also taken care of IP basics. So there are also other strategies. So I think our experts will share also as well, right?
Yeah, sure thing. And it's not all the benefits that registered trademark can give you. So another important thing is that trademark gives you protection on digital platforms. So the registered trademark helps you avoid being blocked on such platforms as App Store, Amazon, via brand registry protection, Google Play, or Instagram due to IP complaints. Also, it gives you the right to file complaints if you see that someone copies your name, your logo, or even your content, especially when the trademark registration is combined with copyright protection. And without registered trademark, it is almost impossible to defend your rights online. A trademark is also a real intangible asset, and it has financial value. You can transfer it, you can sell it, you can use it as a collateral or license it to other companies or private entrepreneurs anyway. And for example, if your brand becomes popular, you can let other businesses use your trademark for a fee through a franchising scheme. And it is the way how to create a new revenue stream for your business, for your company. And register, it's important to understand that registered trademark is not only a legal tool. I would say it is a powerful part of your marketing strategy. And adding the registered symbol next to your brand sends a strong message of quality and reliability. Yeah. And it shows that your company didn't just create the name, but officially registered it and invested time, money, efforts in protecting its reputation. And one more thing, having a registered trademark signals about the prestige of the company, about its professionalism and its values, and plans to act on the market for a long period of time. So consumers tend to trust such kind of brands which care about their image and take brand protection seriously.
Absolutely agree with you, Alina, with your points. Since really, let's say that registering trademark, it's like an investment into future of the company. Yeah, it's not something like um, just it is not. We will do that and we'll forget about it. No, so it's really investment into your company. So you have lots of benefits. Yeah, it's not a formality. It's a key strategic asset that may protect your business. It supports your growth, so strengthens also your competitive edge as well. Yeah, both legally and from a marketing also standpoint, as we mentioned. So, as for trade marks, maybe pretty understandable at this stage. Yes. Let's also talk about patents. Just to say, we know that it protects technical solutions and innovations, right? Not names or designs. But still, let's talk about how companies can protect their inventions, their developments, so to stand out in the market, yeah, and gain a competitive advantage. Maybe the same thing, like the main features of this category.
Yes, as my colleague said, if we talk about trademarks, it is more about some names, some logos, yes, something that can be used in marketing. But if we talk about the patent, it is mostly about the product. That is the value that you bring to the market. And of course, if we talk about patent, it's about more complex technical solutions or methods. And sometimes it can just take not thousands, but hundreds of pages to describe this technology. And what is essential here is that, again, the patents, in the same way as the trademark, they protect the object. But in comparison to the trademark, the term of protection is a little bit shorter. It can be up to 20 years. Of course, when the patent exists, the owner of the patent can use the object in any lawful way, and of course, to commercialize it and to receive some benefits, profits from it. And what is also essential here, I will come back for a little moment that I mentioned earlier. It's about software and program codes. As I said, that mostly they are protected under copyright, but sometimes they can be protected under the patent. And these are the cases when there is some unique method or unique technology. Just for the example, there was a case in the Europe regarding the developers of video game Nintendo. They wanted to protect their codes under the patent, and they managed to do so, but it was possible because they presented some specific sensors, some specific process here that was not presented before to any, I would say, in any country. Yeah? And that is the unique thing that can be possible. But here, generally, the patents are used for some technical solutions here, like complex solutions.
Okay, I got you, and thank you for the example also as well. So let me just compare, yeah, and to sum up this point, and we'll go further. So what we understand, a trademark, it's like your business cards, right? So your company name, your logo, slogan as well, yeah. While a patent, it protects your invention or technical solutions. So one category, second category, and to the first one, it's just put simply, right? The trademark, it answers the question, who are you? While a patent answers, what have you created? So more about the product, yeah, not its name, but its context. So what is it? Its sense. And actually, it's the main thing that now you need to understand just at this stage. So going further and moving forwards, also I have a questions. Anastasia already mentioned a couple things about it, but still I will ask to compare also with the trademarks. What about the duration? So the duration, how we can protect. So how long do these protections of trademarks and in comparison with trade patents, so sorry, actually stay in force? How long time?
Great question. Actually, it depends. It depends on the jurisdiction. However, as a general rule, we can say that a trademark can last as long as you keep using it and renew it on time in each jurisdiction. Usually it's every 10 years. So before the 6 months to the expiration date of the trademark registration, you have to renew it via the specific application to the IP office in the country of registration. However, a patent has a limited lifespan, typically up to 20 years, depending on the type of the patent and the country of registration.
Okay, let's just fix it one time, yeah. So trademarks, it's let's say 10 years, not 10 years, just a sec, and renewal each 10 years, right? Yeah.
Correct.
Yeah, and the patents, it's usually 20 years and no renewal.
Yeah.
So I just make a short disclaimer that, again, it depends on the legislation, yeah, and country by country, it may have some differences, but still, trademarks, it may be renewed and renewed again and again. So the main things here that we should prove our usage, but we not just take it from the public, from the competitors, yeah, but still do not use it and do not allow to use it other people, right? But still we continue with using and really need that protection. But for patent, okay, so you did that 20 years and then it's something that is accessible to public. Anyone also may use that after that period of time. Okay. So now it's maybe simpler for our understanding. Let's also discuss, you know what, maybe let's go this way. Let's go some questions regarding trademarks also. It's kindly like halfly about theoretical part, but also with some practical usage. So what I'm about, usually clients come to us and asking about trademark registration, but what should we know? Not all the time. So first thing, we need to understand what we are going to register, since there are different kinds of trademarks. The second one, someone wants to register just the word, yeah, or the slogan. Someone like the whole design. It's especially so picture plus slogan, someone only picture, and all these things may be like trademarks. And not only these kinds. I'm just mentioned the most popular among trademarks. But still, some from time to time we have some questions about which word can be protected, which one. So no chance to be protected, yes, but still let's discuss. For instance, usually clients ask us, okay, which one I should, which category I should go with, yeah? A black and white version, for instance, or a color one, in case it's a trademark with some pictures, yes, not only the word, or as well. So what should I register? Just a word mark, yeah, or the full design. So the word plus the picture and the colors and all these things. So let's discuss. We understand that each option has its pros and cons, but still, what would you recommend to register?
So the recommendation may vary after the discussion of the client needs, understanding the stage on which the business currently is, and also additional questions regarding the usage of the trademark and so on. So what you register, whether it's a word, its logo, or a specific design, has a direct impact on the level and type of the protection you get. Yeah, it's important to know and understand this thing. For example, registering a black and white version of your trademark gives you a broader protection. It allows you to use in the future this mark in any color variation, and it still will be legally valid. So it could be especially useful if your visual identity of your brand is still evolving. It's still in the process of development, and it could change in the future. By contrast, registering a colored version gives you more limited protection, only for that exact version, including specific colors. But if your brand is strongly associated with certain colors, it's a smart move to lock that down through color registration to stop others from imitating it. Just keep in mind, if later you will decide to change your brand colors as a part of rebranding, for example, you'll need to register again a new trademark and reflect in the new registration those new colors or color scheme, for example. The same principle applies to word marks versus full logos. A word mark in black and white offers more flexibility for you. You can, you or your designer can create multiple future visual styles using that word, and it will be protected under the registered trademark. But if you later change your logo's look and feel, you'll need to register a new version separately as well.
Yeah, we see. So everything depends on the context, on the main purpose here of the business. And again, let's say on the duration of usage. Yes, because it's if it's just the business that is launching the market, it's one thing. In case we have some usage, yeah, and long period, but still don't know why, but maybe for some reasons haven't registered our trademark. Yeah, maybe it's more reasonable to register as it is, not like more wide version, like only word. So that's why it's not only the whole process, not only about the trademark registration itself, but like, I mean, submitting the application, I prepare all necessary documents, yeah, but still to define the reasonable strategy. So after some consultation, yeah, with your team, with your lawyers, to understand what you need to protect and what is the best way. That's why usually before registering, like submitting applications, yeah, we're sitting with our clients and discussing the purposes, discussing the features, some specialities of their business, and then decide. So providing our recommendations, and the clients, of course, decide on their part how to proceed in this case. So, okay, I think it's understandable. Now I want to maybe consider some interesting examples. So to make it more practical, yeah, and compare, I would ask maybe to change the slider for the next one. Yeah, this one point. So we've prepared some interesting things also. So let's consider how it is works in practice. And we have real life examples. So it's about the logo that maybe the trademark, let's say, that everyone saw. Yeah, one is really famous, and another one is pretty disputed. So, and here we have also the questions on the slide. Now we're talking about the first part of the slide. Let's say, yeah. So the first one and the second one pictures. Someone that is upper the two seconds pictures, yeah. And the first one, it's pretty recognizable. So famous brand Louis Vuitton, and I would say iconic monogram, maybe, yeah, L&V. So, and the other is an attempt to register such the trademark, the and Voltaire. And now I just want to ask the participants. So just I don't know, for interest, yet to understand, because you know it's difficult to say in intellectual property law something for sure. Of course, there are things that we can say for sure, right? Maybe that you need to think about that. It's for sure you need to do, but still, I want to ask the question. Yeah, do you consider this trademark similar? Or would you allow the new mark to be registered? And I say the first answers. No, this would mislead the customers. Okay, I see. So do you have, maybe someone have other points of view? So how do you feel about these trademarks? So, okay, then let's discuss. So let's open the situation, what it was about, and if this attempt to register that second trademark for let me remember, sorry, the and Voltaire company, yeah, if it was successful or they have some problems with the attempt.
Oh, of course they have problems. And in this case, Louis Vuitton's legal team managed to block the registration of this ZV, the and Voltaire trademark, which was filed for tech products, accessories, and clothing. And the court found in its decision that the LV monogram is so well known that even in unrelated classes, like electronics, it still triggers a clear association with the Louis Vuitton brand. So that creates a risk of diluting its prestige. Yeah, let's say as a result, registration was only allowed for a limited list of items in the nonce class, like magnets and cables, where the risk of confusion was minimal as much as possible. And we can move to our next part of the slide. Yeah, it's also a very interesting case about Lois Vittorio.
Yeah, even at first glance, the logo shows a strong visual resemblance to LV. So we do not need to be special professionals here, but just to be a bit not so close to the laptop, yeah, and we can see something similar.
Yeah.
Also, what would you say? What was this case about as well, and what was the outcome of this case?
It's also a particularly interesting one. So at first, the European Union IPO, its Intellectual Property Office, concluded that visual similarity wasn't enough between Louis Vuitton and Loewe Vittorio. They argued that consumers are used to different font styles, and the letter composition would be seen more as a design element than an attempt to copy LV's fame. However, the situation changed in 2024. It's that referring to that point that in the intellectual property law, we cannot be always 100% sure about the court's decision, yeah, in this field. So in 2024, Louis Vuitton submitted a full package of evidence demonstrating the strength of its brand reputation, and argued that Loewe Vittorio was unfairly exploiting the LV's monogram's recognition. So at this time, the decision went in Louis Vuitton's favor. The mark's registration was cancelled. And this case clearly shows that even when marks look like just stylized elements here, a brand's reputation, among other, and solid documentation can completely shift the outcome.
Yeah, actually, totally agree here. Just if now we have just seen, yeah, even some stylistic details that seem like minor at first glance, like letter shapes or the overall impression of a trademark, it still can be legally protected by if they are backed by a strong brand reputation. So, and if we are talking about the potential outcome, sometimes like the same level of similarity, but still may have different outcome depending on which companies are involved into case. You see, if it's like strongly reputable, well-known companies, or still not so much reputable, yeah, or well-known and recognizable by the customers. So, and also we have now we just discussed something with science, yeah, something with monogram, but we have another great example, I would say, yeah. We are not just the science and how it looks like, and we have I don't know, some words or letters, but just when the thing is about the color, yeah. And let's take an example where color plays a central role in trademark registration attempts, and how each side argued for or against them. So you can see on the slide now, yeah, it's a pretty recognizable trademark, a brand that becomes synonymous, yeah, with an elegant shade of blue. It's Tiffany. So, and the question is, again, for the audience, so for you, dear participants, how do you think, you have like the question on the slide, but still, do you think that a color alone can be registered as a trademark? And how easy do you think it is to prove that the color is strongly associated with particular brand. So do you have any ideas? In case you have, you may share. In case I see. So we have a really active participant today. Ruslana, I see. Yes, in some cases it can be protected. I agree in some cases. Very smart answers, by the way. So then let's discuss. Yeah, let's tell us please about this case and what was the outcome, what was the main feature of that. So
Yeah, actually, the case with Tiffany Blue is, I would say, unique when they managed to register the trademark on the color. And what was the story? Tiffany as a company started to cooperate with another company, Pantone, and they wanted to create the specific color with the shade under the code Pantone 1837 because of the year when the Tiffany brand was founded. Of course, they managed to do so. After this, the company referred for the with the application for registering of trademark in the US, and they managed to do so and used this color for packaging and sharing their goods all over the world. And what is interesting in this case is that in 2019, there was another company, Seven Seas Fashion House, and they wanted to register their own logo, where there was a part of the logo with this color. Of course, Tiffany felt the opposition in this case, and they, of course, said that they have the rights for this color. And finally, of course, Seven Seas was refused in the registering that exact logo because of maintaining this type of color. And I would say this is really a unique story because, let's say, if I want to register just, let's say, ordinary green color and I will submit the application for registration, I'm sure for 90% that I will be refused in registering this color because this is just green and I don't have like any famous brand. But because Tiffany has like the unique story, they are recognized market, so they managed to protect their brand in color.
yeah. Yeah, so as we just seen with Tiffany, even if even a specific shade can become a powerful tool, yeah, when it's so now I'm just asking you to make a note here to understand the main thing. It's really tied closely to brand identity. So in case the customer associate this color, for instance, yeah, with your company, in this case, okay, it may be approved, but still maybe it's more like exception. Yeah, and this exception may work with a company that have some solid background here. It's not about a new company that only make their first steps on the market. So okay, yeah, hope we are done with that example. So let's switch to the next example, also interesting one, also very famous, but still it will provide us with some foundation, yeah, of understanding of approach. And it's about, as you can see on the slide, Red Soul Louboutin, yeah, and it's the case. So to understand